All right. I'd like to call to order December 19th, 2018 meeting of the Shelburne Design Review Board. Standard procedure is to open up for public comment on any items that are not on the agenda. Does anyone have any public comment?
Are there any agendas? I'm sorry.
We do have an agenda. I don't know if we have any extra copies. Robbie?
Dean's on it.
Dean's on it? Excellent.
Yep.
Thank you very much.
The agenda is also up on.
Oh,
There we
Is there
go.
a sign-in sheet?
Yeah,
The
next.
sign sheet should be in the corner as well. Please do sign in.
Okay. Reminder to anyone, especially if you want to offer testimony or comment, to please sign in so we have a record. All right. Going to open up the hearing. First thing, going to members of the DRB. Are there any conflicts of interest or recusals that anyone would like to mention?
I'll need to recuse myself from items 7 and 8 on the agenda tonight.
All right. And I would like to recuse myself from item number 8, and I'm also going to read a statement about that. So I'd like to recuse myself from tonight's session of Shelburne Green application SUB 13-02R3. The reason for my recusal is an ethical complaint filed by Dean Pierce on September 5th, 2018, stating that I have a conflict of interest which I interpret as a prejudgment of merits associated with Shelburne Green. I believe this prejudgment of merits is related to my opinion dealing with the change in operating hours of a proposed cafe at Shelburne Green. At the March 2nd, 2016 DRB meeting, the Shelburne Green application was presented seeking various updates. Change of cafe hours was mentioned by the applicant along with the concern that would not meet the Stowe Highlands criteria for changing the permitted condition, and as such, the applicant would not be seeking a change to the operating hours. I indicated that I would be in support of the change of operating hours, and I also indicated that I felt that it met the condition of changes in operation of permittee's project not reasonably foreseen at the time the permit was issued. So I'm clearly on record for that particular opinion, and I stand by it. However, I do not have a predetermined prejudice on any other matters associated with Shelburne Green. I have a larger concern about potential limitations in dialogue among DRB members when discussing applications with an applicant, the public, or more revealingly among board members while in session in a public forum. Questions or comments by DRB members might indicate a bias towards a particular position. I'm concerned that this may be used against members as a prejudgment of merits in continuances or future applications. Similarly, DRB members' bias may be derived by specific decision signings. So I'm planning to discuss my concerns with the Shelburne's Ethic Board to gain further clarification on appropriate DRB public discussion that does not jeopardize board members' ability to participate in future applications, as well as possible refinement to my future participation in Shelburne Green applications. Above all, integrity of the Design Review Board is my priority. Any questions or comments from the board or from the public? So I would like to add that to the record for tonight. Okay? And I will be recusing myself from that application. And here is a written copy. So you can pass that down. Thank you. Okay. So with that being said, let's move on. First order of business is to go over the approval of minutes. I guess that would have been the second order of business. So has anyone have any comments on the minutes as they're written and documented?
I have a comment, but I don't know how to solve it, and it may not be worth solving. Under the announcements, under item 1, it says that I recused myself from SUB 1803, which is correct. I also later, during the proceeding, recused myself from CU 1809, and it looks like because it was heard between them, I may not have participated in SUB 110R2. But as long as everybody understands that the sentence in the first paragraph does not completely describe the events that I recused myself from, I'm fine leaving the text the way it is. I think what actually happened is that the time I made that statement at the beginning of the meeting, I had thought that SUB 1803 was the only matter I needed to recuse myself from. And as the meeting progressed, additional information came up that alerted me to other recusals. So I'm not suggesting a change, but I'm just saying out loud, anybody who looks at the vote totals during the meeting and my recusal announcement at the front will see that the math doesn't add up in a couple of other cases.
Okay. Somehow I'd like to have the record reflect what actually happened. Is it possible that we can, do you remember where you made an additional announcement? Do you have a recommendation?
I remember actually speaking to you about CU 1809 just as the matter was called to hearing because some people entered the room and made it clear that I needed to recuse myself. So
Okay.
that's when I recused myself from CU 1809.
Okay, perhaps we can add it there then. And that would be on page 5?
Yes, page 5, 3/4 of the way down.
Okay. We got that? Excellent. Okay. Thank you. Anyone else, any comments?
No comments.
Nope.
All right, make a motion to approve the minutes with the modification as stated by John.
Second.
All in favor?
Aye.
All right, motion passes. Thank you very much. Okay, next application. Application A17-12. Hearing on remand per judge order issued by Superior Court Environmental Division. Judgment order assesses Nathan Burris appeal of Assistant Zone Enforcement Officer's denial of application for zoning permit. Property at 499 Beaver Creek Road is in residential district and stormwater overlay district. All right, gotta do lots. Let's do some swearing of people that are gonna provide testimony to this. Raise your right hand. Do you swear that the testimony you give will be the whole truth and nothing but the truth under pains and penalties of perjury? I do. Thank you. All right, typically, our staff kicks us off and we go from there.
Yes.
If I could, I apologize to just intervene here shortly. I just wanted to bring to the attention of the panel. Attorney Blay and I, well, we haven't met personally. We have had professional interactions. So I wanted to disclose that to the DRB. I work as an attorney and we have had a case together. So I wanted to bring that to the attention of the board in case there was any issue about concern for fairness to the town.
Okay.
Nice to meet you.
Norm, I have to ask you, do you feel this will prejudice you in any way? No. Okay, thank you.
Thank you for bringing it up, though.
Okay, very good. Would you like to get us started, Ravi?
Yes. So, as the chair, of course, you have, I guess, control over the floor, as this is, just like all other hearings, a quasi-judicial proceeding. What's different in this case is I am a neutral party not providing you evidence, but the evidence will be from the parties that are in front of you. The evidence that they provide will be the ones that you will have to utilize in deliberating your decision. Along with that, I do have motions to compel, firstly from the applicant. That was given to me on last Friday, on December 14th, so it was not, I could not include it in your packets. So there's this. On top of this, there was a response from the town representative that was given on December 18th, along with another response from the applicant that was given shortly before this meeting today.
How many documents?
One of each. So I first provided the December 14th document.
Just take one of those.
One of those.
Okay, and there's a different document at the
Is
bottom of
that?
this.
Oh, no, that's still correct. Still 14th,
That one was received on a different date.
December 18th. Okay. Hopefully there's 6 copies.
Response to motion to compel
Response to motion to compel.
is your number 2.
And then this is number 3. So with that, since this is new evidence that is entered into the testimony and that you have not had enough time to prepare, there are certain actions that you can take at this moment. that you can suggest to other members of the board, Chair. So you can have a recess, deliberative session in the middle of the hearing to review the documents that have just been given to you. You can do a continuance. Continuance is pretty standard fare according to the DRB rules of procedure, according to section 7, for any new evidence that has been entered between last Thursday and today. But you also have the choice of having the documents in hand, hearing the applicants, and incorporating it into the hearing.
Okay, what I prefer to do is I would like to hear from the applicants, maybe a high-level review of what's going on, and then as we go forward, we'll see how we feel, okay? Is there any more that we need to see, or is this it?
That's it, but I will say that this is something that needs to be covered first before the remainder of the judgment order.
Yes, okay. Yes, sir.
Hi, Ed Adrian for the
Hi.
town. I just have a procedural question. I just want to make sure that the board has received the environmental court's decision, since they would need to review that on, yeah, okay, great, thank you. Right.
So it's provided in their packets on Thursday.
Yeah.
Super.
And the subsequent motion decision as well.
Anything else?
No, thank you.
Okay. Okay.
So before giving the high-level review, if there's one brief moment for me to address one of the filings. The town's filing includes a reference to my professional employment. I've asked the town to remove that reference for a variety of reasons. I don't think it has any bearing on the issue of whether or not I should be able to build a fence in my backyard. To be very clear, I'm appearing here pro se. I'm here as a resident of the town. I'm not appearing as an attorney. I'm not appearing in any professional capacity. I'm simply a citizen here who is trying to build a fence. I've requested on a number of occasions that the town remove that reference, and they've refused to do so. The rules of civil procedure allow for redaction, and so I would ask the board to redact the reference to my professional employment from the town's filing before getting into the remainder of the document.
As a representative of the town, what's the reason why that would not be done?
So, a couple of things. As Mr. Burr stated, he is an attorney. It is relevant, and the reason why it's relevant is the courts have continually stated that if somebody is representing themselves pro se and they are an attorney, they have a client. They are their own client. And that when there are non-attorney pro se litigants, the courts will give them, and regulatory boards will give them some leeway as to how they are to proceed, since they are not expected to know the rules of procedure of any particular body, and they don't have the training or experience. But if they are an attorney, the courts do not generally give them the deference that they would give a pro se litigant who's not an attorney. As you can see, and I won't get into the substance of it, but there's been some extensive pleadings that have just been presented to you. And I think that it's important, just like any other administrative body or any other court, that the board takes into consideration the professional backgrounds of the litigants so that it accords whatever leeway it's going to or not as part of that proceeding. So that's why we think it's relevant. And in fact, when we told the environmental court judge this in a pre-hearing conference, he thanked us for it. He stated something to the effect, and I don't remember the exact quote, that he would consider that as Mr. Burris would know how the proceedings worked. And I think that's it.
If I can just clarify, it's one thing to state that I'm an attorney. To be clear, I'm not a member of the Vermont Bar, but to reference my job title and therefore my employer is very different than what Mr. Adrian just said.
And we certainly take, and I referenced earlier as well, that I am also an attorney. We take no issue with the fact that you know that we're both attorneys. It's just that his place of employment, my place of employment should carry no weight here. That's fine if you want to consider us both as attorneys. It is who we are.
Any-
Just ask that you take that into consideration.
Thank you.
Redact that.
Any comments from the board?
I guess for myself, I will be looking at you as homeowners, as you said, so it's really irrelevant to me where you're employed, who your employer is, or whether you're attorneys or not. So that's my opinion.
And the board is, I think our concern more is that our employment is being linked in the public domain to our home address, which is why we want the redaction.
Yeah. Query the board, other board members.
I just retired after 40 years of legal practice, appearing mostly before agencies and arbitrators. And whenever I appeared in a private proceeding, someone always pointed out that I was an attorney and by whom I was employed. And whether that's appropriate or not, I've experienced that for 40 years. It's kind of a package deal. I am a little more sensitive to the idea of identifying your home address, but you know, you can't appear as a practical matter, whether you're an attorney or not, for a land use commission without identifying yourself as the owner of property at a particular location. So, you know, again, that strikes me as a package deal. All that said, I completely agree with my colleague that your status as lawyers isn't going to influence the outcome, at least before this board. I can understand how your presumed procedural familiarity might take on more significance in court. We're not a court. So I guess that's the comment I have.
Okay. Any thoughts? Let me throw something out. There's not. So clearly, we've got a lot of documentation. I think a general layman wouldn't be providing all the documentation provided. I'm tending to think to identify them as attorneys, but not link them to their employer might be appropriate.
I have no problem redacting their employer. I think it's
I'm fine.
pertinent
Okay,
that
we'd
they
like to do that.
are
Okay.
attorney. Where exactly is that?
Yeah, how do we do-
Documents?
13 of the town's response.
Okay. So how do we implement these changes? What's the mechanism that's going to happen? Is there a minute taker associated with this?
Well, my procedural question is, can we change the town's response? The town's response is what it is. It's already been made.
It's a good
I
question.
think we've made our point. To make things easy, we'll file a redacted page. Okay? That will say Attorney Burris, I guess, if that pleases the board. Let me just make a note of that. And I just want to state for the record, I don't want to really get into too much detail here, but my entire discussions, dialogue, who presented last time have been with Mr. Burris. I've never spoken, as far as I am aware, other than saying hi. And I'm sorry, Celeste, I don't know your last name.
I wear two different hats, work versus here. For here, I'm Celeste Burris. For work, I'm Celeste Laramie.
Okay. I wasn't aware that she was appearing as an attorney until she told me that. First, when she tried to call me earlier, and I refused to talk to her because I thought she was represented by Mr. Burris. And when she sent me an email a little while ago, which was I think she was putting me on notice that she was also an attorney in this case.
It would appear to me that we all agree that mountains are being made out of molehills. And it seems to me if you strike that entire paragraph, that would probably make for a cleaner record. The one on page 13.
So we're getting off to a start here. We're getting caught in legal gumbo, and we're not getting to issues. So as a chair, I want to strive hard to keep things simple and to the point. Okay? So you've got the floor.
I'll try to keep it under 60 seconds. So as the members of the board may recall, and for those who weren't members previously, we appeared last year following a July 2017 application for an accessory structure permit, essentially to build a small residential fence in our backyard. Our abutting neighbors approved this, our homeowners association approves this, no one objects to it, it's essentially going to be invisible to everyone. The permit was denied. We appeared here and sought at one point to admit evidence related to the town's prior permitting of other fences and structures in periphery buffer zones, and the board declined to admit that evidence. The environmental court found that to be error. The hearing now is to presumably admit that evidence. We have continuously asked the town to provide us with that evidence. They have refused to do so, and I can get into the more granular details if the board would like, but that's, I guess, the high-level overview.
Just a quick follow-up, if I may. I think regardless of whether, after the board reviews these motions, to keep it simple, whether you believe that our interpretation of the environmental court's opinion is correct or whether the town's interpretation, you don't actually have to make a determination who is correct here. What we're asking is that you just consider the evidence. You can give it whatever weight you think is appropriate. Our concern is that really what is going to happen is if you don't consider, if the town does not turn over this evidence and you can't consider this evidence, and we end up getting our permit denied and then we end up back in front of the environmental court, we're going to get remanded right back here again because we believe, of course, that our interpretation is correct. So I don't think you have to decide whether or not one of us is correct or not. If you just consider the evidence, we won't have to go through another procedural delay of us just hopefully getting our fence.
And just one final point. The town has already spent, I think, over $15,000 in legal fees opposing this fence that no one objects to and no one is going to see. It seems like we should just move this along, and that's why we're just asking the board to compel the production of these documents.
Sure, okay. So I read statements from environmental court. What I interpret is that the court's saying they would like to see the evidence associated with permitting that the town has done. So I guess I have a question for the town. Why won't we provide that as evidence?
So, in all due respect, the court decided two things. One, it decided that the town's interpretation of the bylaws on the plain language was correct, okay? And that's important to remember. Number two, it said, but we want to hear if there were structures built in the buffer zones, and if so, what the facts and circumstances. That remains the borough's burden, okay, to present that evidence, if it exists, okay? The rules of civil procedure, Rule 34, which we've cited to and which is incorporated in the board's rules, allows a process for disclosure of evidence. One process is to allow the requester to inspect the evidence. We have offered the boroughs that opportunity. Instead, they've turned around and have insisted that the town do their legwork, thereby increasing the legal fees with what I believe is then the expectation of a double-edged sword in turning to this board to say, look at how much money the town is spending. So we're caught in a little bit of a catch-22 situation. So we're in an unusual situation. It's not a private corporation where there may be secrets. What we said is, here are the records. We'll provide a staff person to help you. They're open, and you can have anything you want. We believe we've fulfilled our obligation, and we believe that this is, as Board Member Blais said, I'm going to be quite blunt with you, and maybe I shouldn't, but this is out of control, okay? This is a fence, and it's gotten to the point where it's a highly legalized proceeding. I want to say that the court's agreed with us so far. I would personally prefer if this ended today. But the fact of the matter is that you as a board are entrusted with upholding the rule of law. So far, the rule of law is on our side, and I believe it will continue to be on our side. We'd like to resolve the matter. We've, as you'll see in the filings, I believe, proffered a very reasonable path moving forward. And I can continue, but you can see,
So, Counselor, can I ask you a question?
absolutely.
So if I interpret the court's, I read the court's opinion for whatever it's worth substantially the way you do. They said that the town's interpretation of the language was correct, but then the judge said that he was unwilling to proceed without, based on the exclusion of evidence of possible inconsistent practices in the past. Now, the record of the proceeding at that point had certain specific requests for information. Putting aside the issue of whether the town has to research the questions and come up with the answers, or whether the property owner is given access to the records and does their own homework, what is your view on whether the scope of the information that is to be gleaned is limited by the information requests at the time of the court's decision, or whether subsequent information requests that are broader than that are also within the ambit of the judge's order?
Member Day, I think it's simpler than that. I think Mr. Burris can have, or the Burrises, I should say, can have anything they want from the town records. They're open records. The question I think that you're asking is there going to be an argument over whether those are admissible when whatever they glean from those records comes before the board?
Well, I just wondered whether what could be admitted is defined, not necessarily limited, by whatever the requests they had made as of the date of the litigation, which the judge makes reference to.
Honestly, I don't remember exactly what that might be, and I'm hesitant to start parsing it right now.
I think your point, it doesn't matter if they do their own research with access to the records, because they find what they find, and then we cross bridges when we come to them with respect to admissibility.
I think if they found 100 records that supported their position, great. If they find, 2 records, we'll deal with that. I mean, the records are what they are, but to say that we haven't provided them, we've worked within the rules. And if you want the town to do it, and for the town to absorb that cost, then we'll do it.
Okay. So, do you recognize that you've been granted access to the records?
I'm going to get a little more granular here, if that's okay. But
Just answer the question first, then get granular.
yes and no.
Okay.
The town has provided us with a spreadsheet detailing every permit that's ever been granted in town. There are 600,000+ cells in this.
Okay.
If we were to go into those, there's a column that provides a project description.
Mm-hmm.
And for, I think, 3,400 of the 6,000+ applications, a majority, it's blank. So you can't just look at the spreadsheet and determine what is a structure or
Okay.
what is a non-structure. So what the town is proposing is that we go through at least 3,400 records individually.
Okay.
And even that wouldn't answer the question, because what needs to be determined is which structures are in a periphery buffer zone.
That's right.
And we've asked the town to identify what are the planned unit developments, the PUDs in town.
Okay.
Because that's where the periphery buffer zones are, and they've refused to do that. So if I can give a more simple analogy, if we asked for the addresses of all houses on a road with a 25-mile-an-hour speed limit, it's as if the town is saying, we won't tell you where the 25-mile-an-hour speed limits are, and there's no sign. So there's no way for us to determine what is responsive to our request.
Are you suggesting that the town, though, has a record or a summary that actually identifies that information that it's declining to provide you?
There are records of every single permit application.
Okay.
Well, right, and they've offered to make them available to you the same way they'd be available to a clerk or an attorney or a paralegal who reviewed them for you. But you're not suggesting that there's some summary that the town actually has that would identify which are potentially relevant permits, are you?
Well, before the prior hearing, the prior DRB administrator sent an email saying that she had spent about 4 hours compiling that list, and the town's attorney directed her to stop compiling the list. So it appears there would be at least an incomplete record. But I don't think, to answer your question, aside from that, I don't think there's a list. I think you'd have to go through individually and look at the permits.
So you got a big database, it's not very sortable. Is it an electronic database, Ravi?
Yes.
Back so many years?
And no.
Yes and no, okay. Okay, so my understanding is that the environmental court has asked for these records, and I did review the hearing prior, and you did have something that was going to be submitted as evidence, but it was denied to be submitted. So that indicates that you did compile some sort of list?
No, that was a limited, basically the spreadsheet that I just described, that was a subset of the spreadsheet.
Okay. So would your intent be to go back how many years in reviewing applications and written decisions?
So the court's decision, from our perspective, calls for the admission of any records relevant to the town's pattern or practice of permitting structures. And so any records relevant to a structure that was permitted in violation of the bylaws in a periphery buffer zone would be under the umbrella of the
Sure.
court's decision. And so I don't
Okay.
think there's any date limit to that.
Okay. So do you have to present the evidence, though, to us? Or, I mean,
I do, but before I
Right.
present the evidence, I have to be given it from by the
okay,
town.
I got that.
But if they're, just help me better understand, because I didn't get your earlier point, obviously. If you're given access to the same document that a town employee would have access to, and if there isn't the partial list you mentioned earlier aside, any town record that, or database that organizes the data for you, why, if you're given access to the data, should you be able to compel the town to go through it rather than you?
The data doesn't indicate whether or not the structure is in a periphery buffer zone. So we've asked the town to provide a list of where are the periphery buffer zones, and the town has actually said they don't know, which is surprising given that they're enforcing this rule pretty aggressively here and spending significant fees.
Okay, so it sounds like what we're doing is we're reducing it to how do we exercise this in practice? So you have access to all the records, so now the question is how do you glean from that data, the data that you need? All right, so the town doesn't have this great filing system that has all these sorts, pivot tables that could be done, so that makes it quite manual. So my thoughts are the town should provide some guidance, but I don't think the town is responsible for going back through years and years of data to compile it for the applicant. That would be the applicant's job to do that. I mean,
I'd ask council to comment on that as a matter of law.
As a matter of law,
Can discovery compel a respondent with information who doesn't have it organized or sorted to sort it for them or not? Because that's what this conversation boils down to, whether it's the town's burden to take this unorganized mass of records and.
Can I interject just something? And I apologize, I'm not an attorney, so I feel kind of surrounded by the legal talk going on here. But,
you pretty much are.
quite frankly, I'm just interested, I know it's just a fence, but I'm just interested in us doing the right thing for these people instead of like, I feel like we're in court here. Maybe we are. So what is the right thing to do for the town to help these people? What is the right thing to do?
I agree. We just can't turn them on to the database and let them go at it.
that's not what the offer was. The offer was to provide, essentially make an appointment to come in. I'm not sure if I used the word appointment, but that there would be staff available to assist them in accessing the information. Which,
Okay. Do you recognize that? Did you recognize that offer?
That was an
That
offer,
is the
yes.
offer. Is that-
Okay.
yeah. Okay. Which we think is a reasonable offer, because either the Burses are going to do it or the town's going to do it. And I think that goes back to Board Member Day's question, which is, we believe in this instance, we've satisfied our discovery obligations.
So you recognize the offer, is that a reasonable offer?
Well, for the reasons that I said before, it
This is
doesn't,
a yes or no answer.
no, because it's not gonna get us anywhere.
Why won't it get you somewhere?
Because,
The issue is that of the 6,000 whatever lines of permit applications there are 3,400 that are blank. So it says, for example, date of permit application, I'm just making up categories here, but date of permit application, address, zip code,
Right.
and then blank. So is it for a porch? Is it for a restaurant? Is it for?
I think you,
Yeah, I was gonna say, if the previous administrator was doing this research already, she obviously was getting her information from documents from somewhere, would they have access to those documents that she was using to determine if the permits were relevant?
Yeah, and he can have access to what the list she compiled. I'm not recalling seeing that list and how it was broken down. We basically have given them access to everything. I want to answer, if it's okay, Board Member Hillman's question. I wish I could give him the fence right now. I really do. But that's not the issue. Because the issue, and this is why the attorney thing is relevant again, is when somebody watches this on TV and they're denied a fence, and they say 2 attorneys came in here and they were given something and we're not getting it, that's where the equity problem comes in.
Right, and that's when I say the right thing to do, that's what I mean, the right thing to do. I get lost in this jargon.
And let me just, I think it's unusual to get into settlement discussions, but they're part of the record. And I want to, and here's what I want to tell you, because you're asking me directly, Mr. Hillman. We offered the Burses the opportunity to go to the Planning Commission and get a rule change so that they could apply. If the Planning Commission did it, they could apply and the rule would be changed and they'd get a fence. Okay? I thought that was a very reasonable offer. We'd stay these proceedings, and if they lost, they'd have the opportunity to come back before this board. I don't know if I'd call it Solomonic, but I think I'd call it fair. Mr. Burris asked not to be involved in those proceedings, I believe, because of his position. He asked the town to institute them on their own. The town instituted them on their own. The select board asked the planning commission to take up this issue. The planning commission took up this issue, and I'm sorry that I'm getting a little upset here. The planning commission took up this issue on November 29th. Mr. Burris, concerned about his identity, showed up at the public meeting, and this is cited in the record, literally told the planning commission that the rule under its current construction did not need to be changed because the plain language of the rule supported his position, which is exactly what the environmental court said is not the case. So if you want to talk about reasonable, and you want to talk about trying to settle, and you want to try and talk about doing the right thing, I would proffer to you that we have done the right thing.
can I ask a
I
question?
think the other comment I'd make on context is we're here on a remand from the court. So we actually have been ordered by a judge to take certain actions. And the actions is to grant the property owners access to certain documents. And the debate is how we manage that access. But if it sounds like we're in a legal proceeding, it's because we're in a legal proceeding. A judge issued an order to
My read
us.
from this was, we're to take a look at that evidence.
The judge
so-
ruled against the board
Yep.
because we excluded evidence of prior inconsistent use. He told us to fix that.
Yep.
That's an order that we're operating under tonight.
And so we need that evidence, and the
Okay.
question is who's gonna get it?
Right.
And in that regard, can I ask a question that's maybe gone over my head? Do the parties agree that the rules of civil procedure apply to these proceedings?
If I can, I think the board's rules state that the rules of civil procedure
All
apply.
right. Then if the rules has there been anything comparable to interrogatories and requests to produce issued in this case?
yes.
We don't see those here.
I think the procedural history outlines the requests that were made with date references.
I don't want to misstate the record, so I'd ask Mr. Burrs to correct me if I'm wrong, but I think the requests to produce were basically emails that he sent me asking for certain documents. If you're talking about something like a formal request to produce, I don't believe that's been proffered. If that's what your question is. But we certainly considered those a request to produce. You know, it's hard because it's an informal setting and it's also a formal setting.
Mm-hmm.
And maybe this is more of a formal setting than others because it's on the record review.
If I could just, I'm sorry.
Oh, I'm just curious, maybe this is a broader question. Does the town have any knowledge, expertise that would help them find the requested information that wouldn't be available to the applicant? Or is it a level playing field?
Ooh, could you expand on level playing field? I'm not
Well,
sure where you're
if
getting.
these folks were to come in and go through the files themselves.
Sure.
They're coming in probably pretty cold. They don't know the ins and outs of how documents have been filed or whatever over the X number of years.
Sure.
But there's probably some knowledge here that could probably find this information quicker, more thoroughly.
Sure. Yes. So if hypothetically, if they were to come in and talk to me and say, I would like to know more information about this, of course, they would of course have full access to that as it is town public records, and I would be able to assist them. Of course, it would take some time to do what they ask for because, like I said earlier, yes and no to our records to a certain extent are electronic, but after a certain point they are in our electronic database. But when you type it in and try to look up that permit, you're not going to find the specific what exactly was built. You'd have to go into our archives and find those original permits and
So
dig
you or
through.
somebody would have to spend a good amount of time actually working with them for them to figure out where to find the information.
I believe so. Yes.
Okay.
Okay, another question of the town attorney. If you're representing the state of Vermont rather than the town, and a comparable request to produce was made to you as an assistant attorney general, do you think the state would have to undertake the obligation to do the search as opposed to saying to the requester, you have to come in and do the search?
I think it would depend on the state agency and the facts and circumstances. I know for a fact that it's been done both ways, depending on how the agency keeps its records, whether they're available in an electronic database, whether there's confidential records in there. Here, they happen to be requesting public records that are open in public access. As you know, Board Member Blay, within state litigation, there can be a substantial amount of attorney-client privilege, other privileges. We're not exerting that here. And so I think it would depend on the situation.
If I can just get back to one comment that Member Day made. I think you had asked about the legal basis for a request, and Rule 34 requires that, or says that a movement can request records in a reasonably usable format, which is the language of the rule. And so what we're requesting here is a reasonably usable format, essentially just to identify what are relevant and what are not relevant records. And to get back to my original point, even going into the archives, as was just discussed, and pulling each of these, let's say of those 6,000 records, there are theoretically 500 that are relevant. There is no way to determine from the archives what is relevant and what isn't. That process won't work unless you know what are the PUDs in the town of Shelburne. And that's, I think, integral to the request.
Okay, I have a question for you. Would you be willing to do the work or to provide someone to do the work on your behalf if paired up with a town official to help make it more efficient?
We're happy to do whatever the board pleases. I think we just want to make sure that the town is meeting its obligations as long as we are doing so as well.
Okay.
Does the town have an obligation to produce summary records that don't exist and that it doesn't have the tool to generate, accept, and response to the request?
You basically, I think your question is, does the town need to create records? I don't believe so.
That's been my impression too. I'm a practicing attorney for 40 years. We don't have to create a record. If one doesn't exist and we give you access to the underlying data, it's as good as it gets.
So I think if I can just distinguish creating a record from what we're doing, the town has actual records of planned unit developments that were created, and we want to know what those planned unit.
Sure. So if the town provides you guidance and oversight on some of that information. Go ahead, I'm sorry.
What do you, I mean, what's that based on? What's your, is that an assumption, or?
So if you look to the attachment to our motion to compel, you'll see an email.
Well, I haven't had a chance to do that yet, so.
Well, I'll give you a preview. The attachment is an email from the town's attorney, which details what records do and do not exist. The town said that it would take them 5 to 6 hours to compile the records, and they're not willing to spend the 5 to 6 hours to compile the records, and so they have refused to produce them.
That was, just so we're clear, that was just for the PUDs. And what we did provide to Mr. Burris, and he can correct me if I'm wrong, is the spreadsheet he was talking about, in addition to what we believe is, Dean can correct me if I'm wrong, because I'm speaking a little bit out of my understanding here, but I believe it's a list of all applications for PUDs going back as far as the list goes. I can't remember if it was the 80s or 90s. Okay. Whether or not those PUDs were created, though, is another story. That was the best existing records that I could provide without the town creating something.
Okay. Mr. Burrows, how far back do you want to research? Do you want to research back to the settlement of the town? Do you want to research 2 years back? How far back do you want to look?
I'm hesitant to give you a sense of an exact date without seeing what the town has. Obviously, if there are, crumbling paper documents, I don't think it would be efficient. So I think my decision would be based on efficiency.
Sometimes that work is not necessarily efficient. It's hard work.
Right.
So my conclusion is, after reading, the judge's decision and listening to this, is that all the documents we're talking about are public record. And the town has made an offer to you to give you some assistance in figuring out the easiest and best way to access this information. And I really think that that's the hard work that will have to be undertaken, and the onus is on you to do that. And again, I haven't had a chance to read this, both the responses, but it's public record. It's hard work, and maybe that's what it's going to end up to be. And I don't think the town is really obligated. I don't know much about Rule 34, but to create any documentation that's going to make it efficient or easy for you to produce this evidence. I don't think that's part of our obligation to you.
I agree with that comment. Just jump back into the date thing, though. Isn't your argument that the outcome that you're interested in is available under certain town bylaws and regulations, and what we're discussing tonight is access for information that will establish or not that they were applied consistently or not? So wouldn't the time period for any factual inquiry be limited to the date that those regulations or bylaws were in effect?
I think that's a fair point. My understanding from the Planning Commission is that when the bylaws were adopted, this particular regulation was included in the original bylaws as a part of the initial regulation. So
I
go
hear
back.
you, and I'm way over my head with respect to the history, but surely we all agree that the time period in question is no longer than the regulation, small r, that applies, right?
Certainly.
Okay.
So would you be okay with doing your own research with the expertise of staff to help you with that, point you in the right direction? I mean, I guess that's where I'm seeing it.
It depends if the information staff is going to provide includes or does not include identification of what is and is not a PUD in Shelburne. If the answer is yes, then we'd be able to go through the list and discern what's relevant and what's not. If they don't, we're a ship without a sail.
So I'd assume that staff would not be withholding information and not
Right.
misleading information. They would work with you to provide you an understanding of what information is there. Okay, so I have a question about procedures. So we've talked a lot of questions going back and forth. We as a board, do we deliberate on this and what our recommendation is back to the applicant?
Well,
To make sure-
I'm going to defer to town council. My understanding is that we're operating under an order to have a rehearing of the underlying substantive case once the evidentiary issue has been resolved. The court having ruled that the exclusion of certain evidence at our prior hearing was inappropriate. And that's what we're
Right.
here tonight. So my sense, subject to comment by Councilor Ravi, is that what we're doing tonight is developing a position on what form of access we will use to comply with the court's order, that we not exclude information. Then there really is nothing else, I believe, for us to do tonight. The next step is that we have a second hearing with the benefit of whatever evidence is developed. And then we reach whatever decision we reach.
On Escort, don't we have to rule on a motion to compel?
That's probably right procedurally, but I'd be interested in.
Could you explain what that means?
Yeah.
Basically, the applicants have made a request of us to compel the municipality to disclose the records. Is that a fair summary? So I think in the first instance, we'll have to vote on whether or not to compel the town to disclose the records.
Compel the records means to grant them access to the records?
No, to give them records.
We have to create them.
Right.
Yeah.
Is that-
Well, a couple things. One is, just for the, sometimes these can get a little bit jumbled. We do represent the town generally. In this proceeding, I'm not advising the board, just so I don't want any deference.
Might I recommend that if you'd like to close the hearing on the motion to compel, as Norm has suggested, that is, of course, that is the first thing that must be addressed for this hearing. So if you'd like to close the hearing and enter a deliberative session to discuss that motion, that is seems to be a logical procedural step. From my understanding of procedure, that a written decision would have to be issued for this as well, to make note of what are the findings of fact the board has made and their decision specifically. So that is something that we can assist you with in the deliberative session.
I would think while we're in the public session, though, that we ought to have the opportunity to discuss the wording of the motion. The operative word, the operative phrase, in my view, on page 8, is the relief requested is to produce the documents, not to give access to the documents, to produce the documents.
I just, if it pleases the chair, I just did want to make one other general observation, which is, and it goes to scope, and it is addressed in the motions, but I think Mr. Verse was asked and answered this question. If you look at the bylaw in question, in, I believe it was March 17th of 2009, that a grandfather clause was put into place, sort of creating a bright line, saying everything that was unpermitted or not permitted in the right way is grandfathered and everything moving forward. We'd say that's something that the board should consider, is that whether or not things that have been grandfathered in are relevant to this proceeding, A. And B, and I think this is arguable, and Mr. Berth and I have gone back and forth on this, but our position on the judge's interpretation is not as expansive as Mr. Burse's. We believe that the judge's decision is limited to Beaver Creek.
That was my read also.
Which would obviously make things easier for whoever was doing the search.
Do you have any comments on granting a motion that requires the documents to be quote-unquote produced? My plain English reaction to that is that means we turn over documents. We don't give access to documents. We turn them over.
I think I have a copy of Rule 34 if the board wants to take a look at that. I only have one copy, but, or I think I have it.
I agree that Rule 34 takes you to a very different place with very different language. But the motion, if we have to decide it in the relief requested section, asks us to issue an order compelling the town to produce all documents responsive.
I think the town can deny the order to compel the town to produce them, at the same time order that the appellant be given access to those records and that the town provide reasonable assistance.
You just grant them access to the documents and give them assistance to reasonably clarify, how they're going to point them in the right direction so they're not wasting their time. And I also think it's a very relevant point Mr. Hillman made regarding the fact that I too believe that the judge is limiting this to the Beaver Creek PUD, but I'm sure that's an arguable point. But.
Any more questions from the board?
I am not clear on what we're really being asked to do here by the judge. Is it, on page 8, he's got a conclusion here, and when he says to make additional factual findings, does that infer that we have to produce it, or?
Means we have to have another hearing.
We have to accept it as evidence in another hearing.
We do the hearing based on any additional evidence that's admitted as a result of the disclosure.
And when he says to reopen the evidence, which the town has, it basically just says to grant access to it. Is that correct?
He's after,
He's not compelling us to produce it.
no, he wants to see it.
Basically a reconsideration with whatever evidence they wish to produce, I believe.
That's what I believe. Okay. Any other questions, comments, questions from the board? Applicant?
No, thank you.
Town attorney? Okay. Procedurally, what do we need to do? I want to move forward here, and I think we need to talk amongst ourselves to understand how we want the town to proceed in assisting the applicant, and how we want the applicant to proceed working with the town. But I'd like to do that as a deliberation.
With something like this, you, as chair and members, have the option of finalizing the record and closing the hearing for simply this portion of the hearing, which is this motion to compel by the applicant. And that in deliberation that we can discuss crafting that message and as well as possible follow-up hearings that the applicant and the town's representative would need to be responsible for.
We'll look to one of our legal people on the board to make that motion.
So just so, do you feel, Rafi, that we can suspend this matter for now, take up the other matters on the agenda, and then come back to this issue in deliberative session? Or should we go into deliberative session now?
No, you can go to deliberate session, yeah. Yes, yeah, you'd have to finalize the record, close the hearing, but you can go to deliberative session after all the other agenda items, so that would be item 8.
So I'll ask again, do you have any other evidence that you would like to give on this motion to compel?
Solely relevant to the motion and not the remand?
Yes.
No, thank you.
Mr. Adrian?
Then I would move
Counselor?
that the evidence be closed.
Just to make the record cleaner, I suggested to ask, does any member of the public in the room have anything they wish to add on the matter that we're discussing? So it doesn't look like we limited the comments just to the party.
Keeping me honest, I appreciate it.
So then, is there anything, the public have anything they would like to enter into evidence?
Mr. Pierce?
I think you need to swear him in.
Oh, yes.
Yes, well, if I'm being asked as a member of the public to make a general comment, that's the capacity in which I'd like to make this comment. And it's simply to observe.
You want this entered into evidence for the record of the public hearing?
Well, Well, if he's not offering factual
Okay.
information, and he's just commenting, that doesn't require swearing. But Dean, if you're going to produce factual assertions, then you would need to be sworn.
Agreed.
So perhaps you can make a judgment about what.
Make your comment.
Yeah, the comment is to, I guess, to inquire with Member Blaze, would this be a situation where instead of closing the hearing, you could recess? My understanding of Chapter 117 is that a quasi-judicial body such as the DRB may deliberate at any time, which means it could do so following a motion to recess, and then you could return after you've done your deliberation, and the hearing would continue, and that wouldn't necessitate a rewarning of a new hearing, so the matter would really be all part. And essentially what the DRB would do would be to rule on the motion, because that's what you, well, I've said enough.
So I guess my only reaction, though, is substantively, if what we have to do eventually, at the end of the story, is to have a hearing with the exclusion of evidence fixed from the prior hearing. Clearly, the evidence isn't going to be adduced, any additional evidence isn't going to be adduced tonight. We're not going to be able to have that substantive hearing. So I'm not sure what we have the capacity to achieve tonight beyond a determination and ruling on the motion to compel. But I'd invite anyone with a view on that who disagrees to comment.
Well, I will say that yes, Dean is correct that that board members could potentially recess the hearing, have a deliberative session right now, essentially call for a deliberative session, and then reorganize and potentially continue the hearing.
So what I would like to do is have a deliberative session after the rest of the agenda.
Yeah, that is also possible as well. From my understanding that if we were to have it after the session, then
We would have to close the matter, at least with respect to the motion to compel.
I think it's somewhat semantical. I mean, if you recess it, the meeting's still supposedly left open for you to reconvene at another time versus closing it and then having to open a new meeting. I think that's how.
I think council has put it in better words than my own.
Can someone reduce this to practice so we can move on? And I don't want to deliberate in public.
Yes.
And we want to come back with a written
Well,
guideline.
I think where we ended up, unless I missed something, is that we invited everybody in the room who has any other comment on the motion to compel, as opposed to the other aspects of the case, to do so. And we've now not heard any additional comments on that.
So I think, if I'm not mistaken as well by the councils in this room from both parties, that one way of doing this is possibly continuing this until the agenda item 9 or 10. And because as chair, you have the ability to reorder, well, as all members have the ability to reorder the meeting and reorganize it as you go. So one way of doing this recess is to possibly move to continue deliberation of this item until after agenda item number 9.
I want us to deliberate and then.
Can I ask just a procedural question? I'm sorry for interrupting. So, but Ravi, if we do all that, and we've made a decision on the motion to compel at the end of the meeting, and we've had after our deliberative session, functionally, is there anything else we can accomplish tonight on this proceeding? If there isn't, then why go through the exercise? Why not close the record now, have the deliberative session later, limited to the motion to compel?
To compel.
And we issue a decision.
That's one way of
That wasn't a disagreement, that was a sincere question, I just wanted to make sure I understood.
That's all I can say, that's one way of doing things.
All right, Norm, you got this?
No, I think it's good clarification.
Yes.
I'd move that the record be closed on the issue of the motion to compel, and that we go into recess, and at an appropriate time later this evening, at the chair's discretion, we go into deliberative session.
Second.
All those in favor?
Aye.
Aye, ayes have it. Thank you very much.
Will it require our presence later? We'll have to
That would not be my intent, no.
Thank you.
That was my part. Okay, you're good. Thank you. Have a happy holidays. You too.
Such a great start.
All right, cookie break, please.
Looks like a bribe to me.
We're all about bribes. Okay. Spoken by the chairman, right? All right.
I'm gonna
I want to clear off the paperwork.
I'm sorry, oh, take two, there's still more.
Oh, boy.
You guys, thank you for guiding your job.
No, we're just stirring the pot.
Okay, moving on to item number 6, application BLA 18-04, application by Lake Champlain Transportation for a boundary line adjustment between 2 adjacent parcels. Properties at 2630 Shelburne Road and 2690 Shelburne Road is located in the Mixed Use District, Stormwater Overlay District, and Lakeshore Overlay District. Ravi, would you be willing to get us started on this after you get your cookie or before you?
I was just trying to help.
All right.
Let's see here. So. Faster? Okay. So, the applicant is seeking to make a slight boundary line adjustment between 2 parcels, as mentioned, 2630 and 2690 Shelburne Road. So with this application, no acreage is being effectively transferred between the two. It's merely a shift in lines on the western portion of 2630 Shelburne Road and on the southern portion of 2630 Shelburne Road. So it's a 1-to-1 shift. By effectively changing these boundary lines, the applicant is also isolating the uses, isolating the use of an indoor recreation use at 2630 Shelburne Road and mobile home use at 2690 Shelburne Road. At this point, I'll defer to the applicant, but as for staff, finally, we have no major concerns with this application. Not that I can think of, in terms of just the boundary line adjustment.
Okay, very good. Is anyone here to speak to this application? Just come forward. We'll swear anyone who wishes to offer testimony.
I'm the applicant.
Great. Absolutely. Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury?
I do.
Thank you. Could you
I'm
introduce?
an attorney.
Thank you. Could you approach the mic and introduce yourself, please?
Yes, my name is Dale Arango, and I'm the CFO at Lake Champlain Transportation Company.
And we are requesting the boundary adjustment to accommodate a sale of the mobile home park to the residents. We are the owners of both parcels.
And how does the boundary change facilitate that?
Well, currently, the current boundary line has 2 mobile homes on the bowling alley lot. And so we want to shift it so that, yes, correct.
Got it.
Here's the little outline.
So you can see in the
Yep.
crosshatched area.
Yep.
Yeah.
Yep, okay. That's very helpful, thank you.
Okay. Any questions from members of the board?
No.
Any questions from members of the audience? Yes, sir. Could I swear you in, please?
Sure.
Do you swear to tell the whole truth and nothing but the truth under pains and penalties of perjury?
I do.
Could you state your name for the record?
My name is Sean Moran. I am not a lawyer either.
Once again, thank you.
You can reflect that. And I don't want offense, so no need to call back the town lawyer. First of all, I'm the president, we have the vice president here of the Lakeview Co-op, which will purchase that big development. We have one question. I represent 64 homes on this, and we thank the Peace Corps. They've been great to us, and Lake Realty to facilitate facilitate the new boundary so that we could get the loan to buy the property. So the two properties will now be separate entities. Our question, if you see, and this is a question for the future, in the future we assume, near future, far future, we assume the bowling alley property will be redeveloped, either by Mr. Pecor or by somebody who would buy it from Mr. Pecor. We have no way of knowing that. Our concern for the residents is the surface road that runs from the park through the parking lot of the bowling alley now, facilitating left turns to go into Burlington.
Could you
I can show you up here.
Yes, please.
Sure. Oh, high tech. I was going to use my hand. So here's the road that runs into the park. It goes through the bowling alley to a light here. Now, the people in the bowling alley take a left to go down to Burlington here.
I'm sorry, where does it go through the bowling alley again?
I'm going to use my hand. So right here,
at the top of the.
this surface
That
road
little edge there.
goes all the way up here. So this little surface road goes right here,
Yeah.
parking lot. This is the road
Got it.
to a light here.
Right.
Now, right now, the delivery trucks, the ambulance, the fire trucks, the school bus would come in to take a left into the park, would come in, go through here to take a left. Otherwise, they can't make that U-turn. It's too tight for them. So the residents are concerned at some point that somebody will petition for this road being closed. My only question is, will that be a separate hearing? Passing this has nothing to do with closing that road, is that correct?
That's correct.
So there will be a separate hearing with the town if this road is petitioned to be closed.
I would not be certain about that.
Yeah, that's a slightly different issue. I think the simple answer is anything we're deciding tonight going to influence that outcome, and the answer is no.
Okay, good. That's exactly the answer I want to hear.
The process that will apply, no, because we don't know what.
The particulars?
Right.
But can we stipulate a right-of-way be granted that would facilitate that in the future?
Chair, not with this application.
No.
This application only pertains to the boundary line adjustment, and for anything like that, that would be site plan review that may occur if that either property were to be redeveloped into something else, but not in this scope.
And Mr. Chair, we are not asking for that because the owners have been extremely fair with us. And I've managed the park forever, and I've worked with them to get this sold. And they've held it for a long time to have it sold to the people who live there. So we wouldn't want to incapacitate the sale in any way. My question was merely, we are not deciding on any kind of closure of that road at this meeting, correct?
Correct.
That's all I wanted to know.
And further, if there's any future development, being that they're budding neighbors, they would get warned so they could.
Yes.
Okay, very good. So,
I'm kind of a hearing.
yes.
Thank you.
Sure.
Good holidays.
Thank you.
Okay. Any other comments from the public? All right, any closing from the board? Would anyone like to make a motion?
Sure. Race to the page. I would make a motion to finalize the record and close the hearing for this application, BLA 1804, as well as a motion to indicate approval of directing staff to write a decision indicating approval of this boundary line adjustment, with one condition, that being the Mylar shall be recorded within 180 days of this approval.
All those in favor?
Aye.
Motion carries. Thank you.
Thank you very much.
Thank you. All right, moving on. Item number 7. Very good. SUB 04-05R4, application by Civil Engineering Associates on behalf of Amy and John Sarr for a two-lot re-subdivision. Property is at 3735 Harbor Road, is located in the Rural District, Lakeshore Overlay District, and Floodplain and Watercourse Overlay District. Before we get started, let's do any swearing in if people would like to talk about this. Very good. Do you swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury?
I do.
Thank you. I might have thrown an extra truth in there. All right. Ravi, could you get us started, please?
Yes. So this is a two-lot re-subdivision. My understanding is that many of you have seen this request before. This was noted in your staff reports as well, that this was an approved re-subdivision from last year. And that this is being done again because the Mylar was not filed within 180 days of the approval, according to 24 VSA 4463. If a Mylar is not filed within 100 days of approval, the plat is void and has expired. And so, therefore, the applicants must redo the entire process in order to get validity for that re-subdivision. So, with that, staff has no concerns that we noted, according to the bylaws that are in effect. The only thing that staff would like to note that upon closer reading this last week is one of the conditions of approval stating that a site plan approval would be required. Staff would like to revoke that. A site plan approval generally is not required for the site for the placement of single and two-family dwellings. From our understanding, this subdivision is only for single and two-family dwellings. If the board sees fit that a site plan is necessary for access, then that's fine. However, in terms of town zoning bylaws, it's not required for this subdivision.
Thank you.
Mm-hmm.
Mr. Marshall.
Yes, for the record, Dave Marshall from Civil Engineering Associates. Yes, that is my fault that the Mylar was not filed in a timely manner. Sorry to take your time up to basically rehash this previously approved application. That being the background, we have reviews of the staff report and concur with Ravi's correction with regard to how it's summarized and the recommended approval conditions moving forward from this particular point where we hopefully can be reconsidered as a minor application and then subsequently submit a final plat application to the board.
Okay, and no other changes?
That is correct.
All right. Questions from the board? All right. So you've got, I don't think we want to continue. So you want to okay. Yeah, so we'll make a motion, move to classify application SUB 0405 R4 as a minor subdivision.
Second.
All those in favor?
Aye.
All right. I move to finalize the record and close the hearing for SUB 0405. And I direct staff to prepare a decision authorizing Civil Engineering Associates on behalf of John and Amy Sarr to prepare final plan application for SUB 0405 R4 with the recommendations. Do these all still apply? Town subdivision regulation, section 610. Applicant must obtain comments from town department heads. Town subdivision regulation section include these in their final plan application. Applicant must provide project review sheet and erosion prevention and sediment control plan, and the applicant must file a site plan review application with their final plan.
Second.
All those in favor?
Aye.
The last part was as far as the site plan application. Ravi just indicated
that out.
that was not
Yes,
applicable.
That can be stricken out.
Strike that out, thank you. I knew there was
Friendly
something.
motion? Friendly amendment.
Move to make that adjustment.
That's item 2.
Yeah, I get it.
That correction, I'm assuming will be reflected in the written decision.
Okay,
Right.
thank you. Did we vote on, all those in favor?
Aye.
Thank you.
Thank you.
Very good, thank you. Mark that on your calendar.
Good advice.
All right, I'm going to recuse, okay, let's go for the next one. I think this is the one I need to recuse myself. So who is the assistant chair? Mr. Salmon. So are we at critical mass with 4? We good to go?
Yes.
Okay, great.
It's a quorum, yes.
Okay, great.
Take some cookies with you.
I'm going to take some cookies. Hopefully there's some milk over there.
Don't disappear. Okay. See if I can remember how to do this. So, we're on item number 8 in this evening's agenda. This is application SUB 1302R3, which is an application by Shelburne Green for a preliminary plan review and site plan review to substantially modify previous conditions of approval. And the property's at 120 Graham Way, formerly 6221 Shelburne Road. It's located in the Commerce and Industry South District as well as the Stormwater Overlay District. I'll mention a few things before we get started. Anybody who is here, I'd ask you to sign in on the sign-in sheet. Anybody who's going to speak to this application, I'd like to swear everybody in all at one time. And I would also ask that you use the microphone, please, so that you're accessible to our vast viewing audience. And any of those who'd like to be sworn in, please stand up and I will swear you in. Do you hereby swear or affirm to tell the truth, nothing but the truth, under the pains and penalties of perjury?
I do.
Thank you. So all but 3 people. Very good. So before we tee this up, I would just like to say we've heard a lot of testimony on this property and various applications. It is getting on in the evening, so I would hope that we could stick to new evidence and that's pertinent to this application. And we'll hopefully try to get through the better part of this in good shape tonight. Ravi, would you like to tee this up and tell us where we're at?
Sure.
Pretty simple.
Yep. So this is a preliminary plan review of the application by Shelburne Green to amend 2 conditions of approval. To amend condition number 1 from SUB, from the final plan amendment approval of 1302 R1, which has to do with the building size, that the maximum building size can be for reconfigured buildings 1 and 5 is 20,000 square feet with the reduced amount of number of buildings. The second condition from that, I'm paraphrasing too, is condition number 7 from final plan 13, so SUB 1302, which has to do with accessory uses in the PUD. Accessory uses with, so retail use is limited to a specific percentage that I don't remember off the top of my head, but 1,500 square feet maximum and 2,500 square feet maximum for accessory food service uses. In addition, in that condition is also a limitation for hours for that accessory food service use, and that those hours must be between 6 a.m. and 6 p.m. Now, the applicant is seeking to amend these conditions in order to, 1, reconfigure buildings 1, 5, and 6 that you can see on the northern portion of those site plans into a 32,000 square foot building, and also to have an accessory food service use be from 10 a.m. to 10 p.m. With this new building, regarding staff's view of this, according to the bylaws, we see no real major issues with the reconfiguration of the buildings, but the board should consider an additional condition that would amend condition number 2 from final plan amendment approval SUB 1302 R1, which limits the number of buildings. So a limitation to believe from 11 to 9, since 3 buildings are now being conjoined. In addition to that, staff also made recommendations for 2 other conditions for the reconfiguration of the buildings. And this is essentially to add some finality to these site plans. Staff saw that it's been 4+ years since the final plan was approved, that going forward, that there should be some sort of finality to the plans that are being presented to us. And that would be the smallest building is the smallest building as seen on these site plans that we received, I want to say 2 weeks ago, along with the total amount of square footage that is as presented on these site plans. We feel that going forward that that the applicants have already built close to half of the buildings on this in this PUD, this south portion of the PUD, and would like to see the fruition, the final plan of this too, in reality too, because staff is also looking forward to the boon of this, but would also like some more finality to these final plans. So with the second condition, regarding the food service use, staff had concerns about the hours that going past 6 p.m. that this accessory food service use, stressing accessory, being something that is incidental and subordinate to the other uses in the PUD. And another word, also using the word subsidiary to the entire PUD, that an accessory food service use that is past 6 p.m. isn't really accessory anymore. It becomes a restaurant, and a restaurant is not a permitted use nor a conditional use in this district, except for in areas 200 feet from Shelburne Road right of way. So this accessory food service use would potentially be in Building 6, which is one of the easternmost buildings in the PUD. This is beyond 200 feet from the edge of the right of way of Shelburne Road, and so with that as well, there is there are bylaws in conflict with this request due to that, and so the hours. With that limitation of hours, it signifies this accessory nature of this food service use that is operating in conjunction with the light manufacturing and the warehousing that is occurring during the day. And that was our previous staff's understanding of this at previous hearings for this matter, that whatever food service use would be here would be during the hours of operation of the other primary uses. So that is an amendment that at this point we cannot approve according to the bylaws in effect.
Okay. Mr. Marshall?
You're good. Again, for the record, I'm Dave Marshall from Civil Engineering Associates. I'll introduce one particular component that the applicant has continued to work with the Gables, and the Gables has continued to work with the applicant with regard to concerns as far as operations within this particular project area. I will get back to that in a little bit as far as some ideas on how to basically allow both parties to be more comfortable with the proposal before the board. But that being the background, because 3 of the 4 members of the board that are currently still standing here, unfortunately weren't around 4 years ago when this project originally started, I'm going to give you just a brief overview of what the original intent of what we call Shelburne Green South is and where that puts us today. So the original redevelopment project was associated with Shelburne Green North, just off the screen here. And those were pre-existing manufacturing buildings that were redeveloped, and the large mass of the buildings was broken up very specifically to basically make it look like a much more friendly structure in support of ultimately leasing out space within the building. The concept for Shelburne Green South was to basically focus on food use type of manufacturing. And because of the unknown nature of future tenants, one thing that was ingrained in the application was the flexibility to ultimately respond to market conditions as they change over time. That being the background, one of the very basic components of the project was a building envelope that basically stated that you could have no more than 70,000 square feet of building footprint area within I'll call it a square, generally in this particular location, coupled with also generally a maximum building size, with the idea again of trying to create structures that were specific to startup businesses. And then out of all that, with the understanding that limiting the entire project to that particular number, there needed to be some flexibility, and ultimately there was a condition of approval that one of the buildings could be up to 20,000 square feet. So the idea again was to basically make sure that we didn't end up with either what's down at Teddy Bear, which is 70,000 square foot building, or these particular existing buildings, which I think again was successfully broken up as far as its mass, but this western building was 43,000 square feet, and this particular one was just a little less than 30,000 square feet. What my point is that it had always been the intention to basically enable flexibility as tenants became available. For you to go and build all of these buildings specifically in these footprints would have precluded that flexibility to reflect exactly what each particular lessee's needs were moving forward. In this particular case, what has happened is we have one particular lessee that has been very successful, and that is Fiddlehead. They started very smallly in the north end of this particular building, and their business has succeeded. They want to stay in Shelburne. They initially identified and have invested heavily in the occupation of this particular facility, and even since this original application was brought before the board early in the summer of this year, things have continued to grow at that particular facility. At the same time, the issues in regards to how to cohabitate with the residents of the Gables that are located out here on the east side continue to be real issues that we all want to basically manage. When we appeared before the board previously, the residents of the Gables were concerned about uses that could adversely affect the enjoyment of their homes. And out of all that, there was a screening plan that helped try to create a separation. Embedded within your regulations is a 150-foot setback between this particular use and the residential use, which is more than the 100-foot standard on the perimeter. So that being the background, every time this particular project has taken a change, because that's inherent to the nature of trying to lease out buildings, create building space that's specific to a client's needs, with the understanding that there is a maximum number of 70,000, just a little bit over 70,000 square feet. The reason I mention that number is because that's what the traffic studies are based upon. That's basically what the sewer and water needs are based upon. Traffic and parking, I mentioned that already. But anyways, as far as kind of like an umbrella understanding of what has been acknowledged and proceeded with as being acceptable, the applicant is basically looking to stay generally within those particular parameters. However, again, with regard to the flexibility, the Fiddlehead ownership has expressed interest in basically continuing their operations, expanding upon them, and that's ultimately what is the request before you right now. What I want to introduce as new information is that the most recent discussions with representatives of the Gables has indicated that that they have reviewed some revisions to what is actually in your application right now. To the point where the hours of operations of the proposed food service would change. An important point to make in regards to this particular industrial use is that currently Fiddlehead is operating 24 hours a day. And this application is basically seeking to take the previously approved food service that was approved for 12 hours of operation from 6 a.m. to 6 p.m. and basically shift that time to 10 to 10. We're now working with the Gables on how to come up with a number that's somewhere in between the two, to at least allow the neighbors to come to before you and support that particular proposal. The question, the challenge that we have right now is that there's also a second component of not only beyond the operating hours of the food service, but also the footprint area of Building 6. And right now, one of the things that as this particular business has grown and been successful, it is finding that it needs more square footage. One thing that we've always tried to do with these particular designs is, again, to break up the mass so it doesn't look like a 43,000 square foot building or whatever we inherently have had, I should say, previously in this industrial manufacturing facility or in the storage facility that's down at Teddy Bear. So what we're basically doing is coming before the board tonight and asking for some guidance on how to amend the application materials that are before you right now in a way that allows for the process still to move forward, but in a way that the board is comfortable with. Specifically, probably the biggest component as far as the change in application is that Building 6 would become a little bit longer and a little bit fatter. So the numbers would change from the 32,000 square foot number that's before you right now to 40,000 square feet. And the question for you, for the board, as far as procedure, is there's no way that you can review that because we haven't even given you any plans in that regard. We're still working with the Gables. We don't want to provide plans to you until we've worked out the details with the representatives of the Gables. They've been very patient with us, and we want to be respectful of them also. That being the background, Ravi, I'm going to ask you a question with regard to how this application was warned. I heard you make mention to substantial changes to conditions of approval. Would that still allow us to change the application materials before you right now without having to rewarn or reapply moving forward?
I will refer to the DRB Rules of Procedure, Section 7, that any new information that's provided may cause continuance in hearing.
We know that.
Yeah.
That's good.
And so that's
We're with you.
So with any new evidence that either the board can request or that you could provide, I guess would depend upon the sentiments of the board first and foremost, but it would also probably require continuance. Do you have these plans?
We do have sketches, if it's okay with the Gables people that we share.
See a new plan.
Yes. You want to see a new plan.
I'm the closest one.
Yes, you are. Mrs. Hinsdale, right?
Yes.
Yes. So
before
based on
providing
that,
the plans, I will defer to the chair to run this hearing.
So what you're proposing to do is enter some new evidence in to the hearing.
I think it's more informative as far as to assist the board in understanding the scope of the changes so that we could make an informed decision on how best to proceed with this particular process. The applicant would like, in the ideal world, to have this particular hearing continued so that new information can be provided to staff and the board in a timely manner, that we have had the opportunity to work out the details with the Gables so that we're all on the same wavelength as far as the proposals, because again, a lot of the discussion that occurred 4 years ago, 2 years ago, was because of concerns of the Gables. So out of respect of that, we are coming much closer as far as agreement on how to enable the project to proceed in a manner that makes sense as far as growth and still recognizing the compliance issues that are required. That being the background, we're just looking for time and want to make sure that the board is comfortable with simply a continuance to enable the new information to be generated and then submitted to the board.
If the board chooses to admit this evidence into testimony, staff would recommend a continuance as well for staff to recommend to review these new materials as well.
You're suggesting we continue that and not review this material as part of the meeting tonight, or?
That's wholly up to you, but staff does need the time to review and provide analysis.
That's, I agree, but I don't think it, we've got quite a crowd of people here. We're not making any decisions at this point. I mean, in a sense, we're kind of reverting back to almost kind of a re-sketch plan review here. This is a significant change, so.
And that's why we wanted to have the discussion to make sure, to understand what the board's position was and to basically make sure that whatever questions we could answer would allow us to be able to move forward. I guess the important thing I mention is that, no, I'll leave it at that,
Yeah,
Mr. Chair.
I mean, I have no problem admitting it, basically for just informational purposes informally at this point, so. Anybody have any objection to that?
No.
All right, so then we will admit this into evidence. Do you want to,
Norm and
have any
Al?
type of attribution to this? What do we want to call it for the record?
Call this Exhibit A.
Yeah, we'll call this Exhibit A, which is 4 sheets.
So A through D accordingly to the pages, what are
Well,
the
it's
pages?
A1, L1, A3, and A2.
Okay.
And these are dated, revision block dated 12/17/18.
Somebody walk us through that description that you just circulated. It's one thing to have one piece of paper for 13 people, but I think you might want to walk with fingers pointing very clearly as to what's in that building and where it is.
Sir, we're gonna do that.
Thank you.
That's part of the process.
You can't see that. Okay.
I'm good. I mean, I've got these in front of me, Dave.
If anybody wants to come around and be able to see it better, then that's an option. So.
Dave, please you pick up a microphone.
Oh, microphone, Dave.
Test, is this working? Very good. So in this particular case, this particular plan shows what is called Building 1, that's existing at this particular location. And the application seeks to connect Building 5 to Building 1, and then basically Building 6 into Building 5 also. What I mentioned as part of the previous discussions was part of the goal of basically meeting Fiddlehead's better understood needs in regards to space was to take Building 6 and make it slightly longer and to basically widen it in the east-west direction. What we like about that particular approach is that it, again, is about 700 feet from Route 7, so in regards to what anybody would experience from the public points of access, it would be something that, again, because of the nature of the jogs in the buildings, they would look very much, again, like different buildings. They are connected, but nonetheless, they would not, again, approach one of the classic square or rectangular buildings that you might see as in regards to manufacturing use. So again, trying to create some interest with regard to the building layout, but at the same time also to address some of staff's comments with regard to how square footage is computed as far as the food service area as well as the accessory uses that are allowed as part of the previous approval from the board. And out of all that, one thing that when we go to the second sheet, nope, wrong plan. Okay. With apologies to the viewing audience, that was actually a good before and after. This plan for the board members that weren't involved years ago showed the concept in regards to the 12 buildings that were conceptually laid out for a starting point in regards to the project. And this particular one, you can see, starts to move the mass of the buildings from south to north. We've heard concerns in the past for those residents of the Gables that are closest to the property, that anything we could do to basically move it away from that particular residential area would be beneficial. So those are the types of things that we're still working with the Gables on, as far as, again, trying to create separation between this particular land use and their residential use. One thing that, again, you'll see different is that the buildings that were originally on the south end of the development area are starting to disappear. And that being the background, it's just a byproduct of, again, taking the mass that were, again, shown in 12 buildings and basically moving it up in the northeasterly direction. So that's a little bit of the overview as far as how this would morph as part of the current application before the board, and as far as where the applicant would like to go based on the preliminary discussions with the representatives from the Gables. And that being the background, wanted to basically get an understanding of whether the board, felt that they could enable a continuance to allow the new application materials to come in as far as evidence, and it would also allow us to also address staff comments that were generated as part of the existing staff report.
I have no issues with doing that. I mean, we're basically really kind of tabling this application until you put pencil to paper or move some electrons around and tell us what you want to do.
I'm sorry, Mark, they can't...
I'm sorry, I can't hear you, and I'm very interested in hearing what you're saying, so.
I have no exception to them going back and basically tabling this this application and let them go back and continue with their concept here.
May I make a comment now? I am sworn in.
Yep, I wanted to just ask one more question to David, but now you can go ahead. I can do that later. Go ahead. Go ahead. Go ahead. You may end up you may be asking my question. Go ahead.
Well, we'll see. My name is Ann Powell. I'm the president of the Board of Trustees Board of Directors at the Gables Association. You've heard me before. And the one comment I do want to make, and some of this is explanation to some of the other owners from the Gables who do not know this. This change the board learned of mid to late Saturday afternoon of this past weekend. And so it came as something of a surprise to us. We had met previously with representatives of Shelburne Green, and we then arranged a meeting with Norm on Monday afternoon, I believe it was. The board met with him and got some further explanation. But because of the crunch of time, we have not had the opportunity. Again, actually, the board met again, most of us, this afternoon to do some more thinking and talking before we came here tonight. And my apologies to the rest of you who don't know this, but there was no time to tell. And I will say that we have been working friendly way with them and are working together to reach, something that will satisfy both parties. We have not seen the absolute final plans, even a plan that I got tonight, I was told doesn't have everything worked out. Our concerns that are addressed by this are the ones that we have stated many times about the location of the cafe and the hours of operation. And we don't have those settled yet, but we are working and would like to continue to work to see if we can come to an agreement. So that's where we stand at this moment. Don't know if that answers
Well,
your...
you got a couple of days. Jump on us, because we're just seeing this right now, so. And I'm encouraged that you're working with the applicant, and hopefully you can keep moving ahead. So, yes, sir.
My name is Peter Regan. I'm a resident of the Gables. And I was on the board 4 or 5 years ago throughout the process of when this project, the preceding project, was proposed. And we worked with Graham Goldsmith and his son, and it was a very admirable project. There was the old Snelling buildings, which I was familiar with, and they've rehabbed them, the buildings on the top on the north side. They've done a nice job there, and they brought in some companies that fit the original intention. The property is constrained by the zoning of the town of Shelburne, and the idea was to have light manufacturing, and there was no intention of a restaurant. In fact, a restaurant is not permitted beyond 200 feet from Shelburne Road, as you may or may not know. So the restaurant that's functioning now next to the Fiddlehead Brewery, that pizza operation, is within that zone. So the rest of the land was considered restricted to light manufacturing, and the buildings and original companies that came in pretty much fit with that. And we signed a letter of understanding with the Goldsmiths about 2 years ago, and it's in the record in the original approval of the project. Now, I went through this very well-prepared documents here that were provided, what's called a staff report. It was listened to the letter that we got about 4 or 5 days ago. It was attached, was available. And throughout the staff report, reference is made to the original zoning of this property. And in my opinion, Fiddlehead is not an appropriate as they planned for this property, and they should have been advised that, and obviously they weren't. They wanted, there's been a lot of discussion how we're going to provide, appease, or accommodate Fiddlehead. Well, I was along this thing for 5 years and watched the process go with the town, and the staff report brings us out page after page. It's not an appropriate use to have a restaurant. The restaurant was proposed by Graham Goldsmith Jr., not as a restaurant, but as a food purveyor for the people that worked at these companies. And that's why the hours were set to close at 6 p.m. when the companies so largely would close. Now, this new proposal is for a restaurant to be open till 10 o'clock and all this, and it's just not appropriate. And then one other thing I'd like to add in reading this report, the documents, including this stuff, was presented to this board in July and August, probably back to June, and we came with great interest to the meeting that was held September 6th, which was warned to discuss the Stowe matter of zoning, changing zoning plans. And of course, we came down here, and the Stowe thing was never even discussed. It was just a rehash. And the reason was, obviously, that this new application had been made in July, August, and September, and Goldsmith had no interest in the old application. They had done a lot of work on this new one. And what I found very disturbing was that this was never mentioned, and the September 6th meeting, and for the board members, was just irrelevant, because it was, Goldsmith had obviously was preparing to withdraw their old application and put this new one in. But I would rely heavily on the staff report, and I agree with everything they say. The proposal is not appropriate to the zoning of this property, and it's been nurtured along, and I don't think the Gables, we have a letter signed by Graham Goldsmith dated 3 years ago that there would be no noise, there'd be no this, that, and the other thing. And I don't think, if you read carefully what your staff has prepared, that this will not go forward. Thank you.
Thank you, sir. Is there any other comment from the public or questions of board members? Yes, sir.
I'll take care of this question. My name is Ian Rutherford. I'm a resident of 132 Covington, and that's the middle of that little jog up, no, the one up there. We bought, I'm sorry?
Your last name?
I'm a resident of 132.
Your last name, I'm sorry.
Rutherford.
Rutherford, thank you.
And it's on the sign-up sheet here that it's at my feet at this point. Anyway, the point that I want to make is that a brewery is not necessarily a noisy operation. It could exist within an industrial park as a light-duty operation. The thing that bothers me is when you say it's going to run 24/7. That gets to be a problem not because of the brewery noise, but because of the noise of the cars and the workers who are coming back and forth to get into the brewery. But the thing that is really a scary thing is that some idea of having an outside grill or some place outside tasting room where you are going to get noise, and you're going to get noise late in the day, you're going to get noise up until 10 o'clock at night, and that is definitely not an appropriate thing to have. I know that a brewery would find it very nice. It's nice to have a tasting room and a place somewhere on their premises. They should have found maybe a different location if that's what they want to do. And that's to make this long-winded story a little bit shorter, if I had known that there was going to be a potential of having an outside restaurant that close to where we had bought, I would not have made an offer on that property in August of this year. And I think that tells me that that's depreciating the value of the property that I have just bought, and is depreciating the property of everybody else in the Gables. So any idea of an outside deck that's open after 5 o'clock in the afternoon, I would say, is a non-starter no matter what you do.
Thank you, sir. Anyone else? Dave, do you have any further comments?
Just very quickly in regards to the future plan, things that we've tried to do is create this horseshoe effect that basically creates the activity areas within the perimeter buildings. So again, the original concept of basically the horseshoe shape was to basically keep the activity areas inside and buffered by the buildings themselves. So we basically have what's called a cold side of the buildings where there's no activity as part of the buffer to the residential uses. And that's still would be the concept with regard to the future proposal. That's before the board. Things that are of interest is that currently they're operating 24-hour, Fiddlehead is operating 24 hours a day, and there is no buffering right now because these buildings haven't been built. So at this point, we haven't gotten to complaints as far as the movement of vehicles during the other 16 hours that most of us aren't working, but nonetheless, people are working at Fiddlehead today. We feel that obviously being able to enclose this particular area helps create more of a private separation between the activity area that's in front of the buildings and, again, the remaining residential use out in this particular area. So those are things that we've tried to integrate into the plan and trying to reinforce as a means of, again, dealing with the concerns with noise, odor, and traffic. So in this particular case, we're not looking for any more square footage than what was currently approved before the board. Points of interest with regard to the food service is that it's currently approved for this particular property, 2,500 square feet. So at this point, we're just working on how to best integrate that into the buildings in a way that makes sense in regards to how to basically support these particular, the entire campus of employees that are here. And no, I mean, I'm not going to say there isn't going to be people that come out of the general public and come into this particular site, but it's not a standalone restaurant. This is basically a cafe, and we're not proposing any changes from what we presented to the board previously about that. So if you could imagine a cafe where people are working behind the counter and making food for you and giving it to you, and you go and sit down, that's basically what we're talking about. We're not talking about table service, waiters or waitresses or anything of that nature. So the character is, again, an important component of recognizing what the board gave approval for before, and again, carrying that same concept forward. If we go and put golden arches out front, that's a big change, and that would not be acceptable. So with regard to character, we're basically maintaining, again, the same scope of what had been presented to the board, and the board found was accessory and subservient to, again, the 140,000 square feet of space that's here. So without belaboring the issue any further, I think we'll proceed with that for now.
I'm Jane Knowlton. I'm the daughter of Ann Knowlton, who lives at 121 Covington Lane, and I spoke in September when they had the meeting about the concert and the noise level, and I understand that the concert issue is a separate issue. However, if that goes in and there is increased desire to have concerts, you can see where people would want to go to the cafe and there would be travel back and forth. And my concern is that something may be approved today, but then later down the road, something else would be proposed, and those concerns would not be not be considered because something has progressed to this point. When that concert occurred, it did not have a permit. A permit was granted retroactively. The noise was so loud in the Gables, with the windows and doors closed, the house shook. And we don't live right next to it where Nancy Hinsdale lives. We are farther down around the bend. And if we heard it in our house, I can imagine what those units closer heard it. I understand that the concert issue is different, but when you have people there late at night, noise carries later at night, and you can hear it. And I just don't think it's a wise use. Thank you.
And we don't disagree that, I'm sorry, I just wanted to respond that though anything that is out of the normal, those special events need to have their own permit. And all of the conditions of that particular permit obviously are going to be created in a way that they are, I would like to think, representative of the issues at hand. But that's something the town gets to deal with, and the applicants have to deal with. This particular project doesn't have anything to do with those special events. And that's why they're called special events, because they are just out of normal. So I think it's important to understand that, to advise staff yourselves that whenever something comes in, that you would like to be notified of that particular aspect so you can be heard also. I don't know how that's handled administratively, but nonetheless, any of those special permit applications, they're special for a reason. So out of respect of the neighbors, I can only advise you that that would be at least one way to basically hopefully cover your concerns.
Just to be clear, staff does not, Planning and Zoning Office does not issue special permits, and we regard all approvals as only things that are specifically listed in the approval. Anything that is not specifically listed in the approval is not a permitted use, and that includes concerts in this approval. This is a view that staff has repeatedly let the applicant know in the past, and has faced issues with this in the past, and we do have record of this as well. So if record would like to be available for this, this can be made available to the board. However, as David Marshall has stated, this is something that is separate from what is pertinent right now. However, regarding these tangential uses, something that staff did note was that since this is only specific to Fiddlehead and there are other food service manufacturers in there, the applicant needs to keep in mind that only one accessory food service use is permitted for the entire PUD, that it must serve the entire PUD, and that if it's only Fiddlehead's benefit that this is occurring, then that is something that the applicant must make some sort of I guess acceptance for, and certain latitude for, to accept other food service uses to be allowed to utilize this accessory food service use in an incidental and subordinate way that would facilitate all primary uses in the PUD.
Mark, you got one gentleman.
Oh, I'm sorry, sir. Go ahead.
My name is Laval Thibodeau. I'm 134 Covington Lane. The middle block here, the middle one, the middle unit, right there. It's great because from right now I can look out and I can see all the light shining from Fiddlehead. It's nice. You can hear the diesel engines even without my hearing aids, if I have the window open. Fantastic. The other nice piece is I'm just thinking of hearing people coming out at 9 o'clock at night, 9:30 at night. Now, I don't know about you, but food service versus a bar versus food service versus a bar. My sense is that they're selling alcohol, beer, whatever you want to call it, with some food. It's different from just serving food. That's till 6 o'clock at night. 7 o'clock at night, 8 o'clock at night, I don't know about you, but when the bars close at night, people don't humbly get into their cars nice and smooth. They go out, they make some noise, they talk, whatever. Right now, I can hear those diesel engines. If I close my door, my windows, I'm good. In the summer, sitting on my deck, I'm looking out. Foliage. People yelling, people having fun. I have no problem about drinking alcohol. I just want you to really think about this, because the precedent you set now will be in the future. Thank you.
Anybody else? Ken?
I'm Ken Albert, Shelburne resident, and also the proprietor of Shelburne Vineyard, which is across the road. And just an observation on this, I think the board is obviously have an obligation to make sure that the residents that are closest to it are protected. But I think there's also a larger audience that I think you're responsible for, representing the entire town. And this is I think, a very important resource, not just perhaps to Shelburne, but to the region and maybe even the state. It's basically part of what is in the state of Vermont now a very important sort of movement, economically, socially, land-wise, land use-wise, for craft industries. And I think somehow the challenge of the board has got to be a way to not just facilitate, but encourage something like this, at the same time protect the residents. But it's not just the residents. What I'm saying is you've got a responsibility, for the town of Shelburne, the 7,000 some odd people in Shelburne, and maybe even a larger audience as basically officials in the state of Vermont. What's right? And how's the best way to do something like this? It was originally zoned, when I was on the Planning Commission, we had the vision that this would be light industry. It would be maybe another IBM. We had that kind of delusion. Of course, it never developed that way. Of course, if it would be an IBM or something like that, the noise and the pollution level would be vastly greater than you have today, with much, much, much lighter manufacturing than something like we envisioned. So, basically the residential and this commercial were envisioned in those days, and somehow, how do we make it work? That both the residential and this commercial establishment can coexist as peaceful neighbors.
Thank you. Mr. Halbert?
Good evening. Norman Stanislaus. A couple things I'd just like to mention. And number one, I won't spend a lot of time on the special events issue. However, I've worked very closely with Matt associated with the special events. And obviously, at some point in time, when in fact Matt needs a special events permit, he's going to have to apply by certain criteria, so on and so forth, in order to obtain that permit. But Matt has also said that he has no issue with a maximum time limit in the evening of being 7 p.m. for the cap of any special events that he does require a permit for.
You know, I don't want to, one thing that I'm going to suggest to you, sir, is that, you know, some time ago in one of these hearings, there have been many, we talked about seeing some type of operational plan that kind of tells us exactly the nature and characteristic of the food service operation that you're proposing, as well as anything else. So I think we ought to, we've asked for that. I don't believe we've seen it in detail. This goes back to when Mr. Bradley was representing you folks. And so I appreciate that, but I think that's a discussion
Understood.
for another day.
And the other, I've heard comments about the hours of operation of the cafe, serving the PUD as a whole. And tonight at 6:30, I happened to take a drive down to Shelburne Green and just count the cars in the parking lot for the businesses that were still open. And at 6:30 this evening, there was still 21 cars in the parking lot for the businesses that were still open. And two of them cars were only at Fiddlehead, which is operational 24 hours a day. So the 19 of the balance were other businesses within the PUD. So that's really all that I have to add, aside from the fact that I had been poking around, questioning, you know, what's going on at Felino's. Has there been any issues with the hours of operations? And my understanding is the only issues that there has been at Felino's is parking issues, but no other issues as far as when people finish up at closing time, evacuating and leaving the premises and the business, so on and so forth. So that's all I have to add. Thank you.
Thank you, sir. Any board members have any questions they would like to ask of the applicant? Just a moment. Norm? Dave?
No, I'm good. No.
Okay. Mrs. Hinsdale?
To the for instance, well, I'll say it this way. I think there have been so many changes in what we and young Mr. Goldsmith planned and had such great hopes for, that we need a new start. We need the whole thing done again. We need to hear from Act 250 again. The swamp has gotten much bigger in the 4 years that have passed. I hear that the fire department is concerned about the dead cattails and fire. Another reason that a restaurant at the back is just not a good idea. And taking square footage that it was allowed for the first plan, where each little industry could, if they wished, use 20% of their business for retail, they're going and adding up 20% of every single building and saying, this is what we've been approved for. So I think we need a brand new plan with what you're doing for buffers and so forth. We live just wonderfully right beside Teddy Bear because they did the right thing and made the residents happy first.
Thank you.
Thank you.
Thank you. Is there anyone else? So I think, David, if I understand correctly, we're essentially looking for a continuance. In order to do that, we need to continue to a date specific in order to do that. I mean, do you have a date in mind in which you'd like to present your new plan?
So I'd like to add, obviously, we're working very closely with Gables. No question, we're approaching the holidays, and the president of the board has requested that we respect the holidays and the fact that she may not be able to get all of the board members together so quickly. So I think at this point, that is a difficult question. I think as far as the proposing a final plan to them, as far as the elevations and the site plan, so on and so forth, we're very close to that, and I think that we can have that finalized this week. And I guess my comment would be, what would you think, and would be realistic for a timeline for us to continue to work on this in order to come back before the board? Do you have any thoughts?
Yes, I know, it's been 4 years, I understand that.
If you don't mind if I step in regarding scheduling and,
Yeah, I was gonna ask, how are we looking?
yeah,
Sorry, Rowie, I didn't hear that.
if you don't mind me stepping in regarding scheduling, staff would like additional time, we don't see January 2nd as a possibility. January 16th, that agenda is pretty full at the moment. So,
Yeah.
yes,
They've
so-
got to submit their plans, he has to
so
review, so.
the ensuing dates in February would be February 6th or February 20th. And then there's also March, so that would be, the top of my head, March
6 and 20 again.
6 and 20 again. That's what I was thinking too. Yeah. So those are the options that staff I can think of off the top of my head.
And just, you can ask for another continuance if you're not ready, so it's not,
I think at this point, I think if we were to look for February 6th, that would give us a good half of the rest of this year and half of January to work out these final details with the Gables to come up with something that's acceptable to them. And just like you said, if necessary, we would come in and request if we feel that we have to change that date.
yeah, I think it's easy. I think it requires an email, is that correct, Robbie?
Yes, simply an email. Would like to add to that staff would like all revised plans by if February 6th, then probably January 18th for not only staff but also town departments to review.
Understood.
Doable? I would say, yeah.
Yes.
At the latest, the 18th.
Yes.
The more time, the better, and.
Yes.
Because we've got to solicit, other departmental input. And
Understood.
so forth, so.
Yes. Thank you.
All right. So then I would move to continue the preliminary plan application SUB 02R3 to the February 6th, 2019 meeting. Seconded. All those in favor?
Aye.
Aye. Very good.
Thank you for your time.
Thank you. So who'd like to run in and grab Jeff and John? All right.
Getting cold myself.
So get moving? I'm gonna leave that to the real chair. Hello, excuse me. If you guys wouldn't mind clearing the room, and we've got to get some other people in here, and we'd all kind of like to go home too here. We got that little guy's ready, Magenta's ready to hang around.
She is. How old is she? About 4.5 months. Pretty good.
She's been a good girl.
She's been great.
She needs mom in the evening, so it wasn't good when she was home for hours and hours. So. She's a good girl.
Nope. Yeah, that being said, I think we don't have any other business that I'm aware of. We just have to sign decisions. Yeah, take a bunch.
One is enough.
Oh, they're good.
Very good.
Jeff. Hey, Jeff, do you have any other business we want to bring up before we close the hearing and go into deliberation?
No.
Okay. All right, so I then would make a motion to adjourn the meeting and go into deliberative session.
Second.
Seconded. All those in favor? Aye. Aye. Okay.
All right. Let us know when we're off.